Welcome back to the deep dive. Today we're tackling a subject that, well, it sits right at the intersection of tragedy and legal theory.
It's a heavy one for sure.
We have a stack of documents here centered on a landmark Ohio Supreme Court case, Bennett versus Stanley. And it's a case that really forces you to look at the hard boundaries of, property rights versus the heartbreaking reality of child safety.
Absolutely.
Yeah.
And legally, it's a fundamental turning point in tort law. It represents a collision between two very powerful ideas.
Which are?
Well, first you have the historical right of a homeowner to do whatever they want with their land. And that collides with this evolving duty of a community to protect its most vulnerable members, children who just don't understand danger.
And to set the stakes for everyone listening, the facts here are grim. We are talking about a 5-year-old boy, Chance, and his mother, Cher, both drowned in a neighbor's abandoned, algae-filled swimming pool.
It's just awful.
So the central tension we're going to unpack is, how does the law handle that? I mean, does the property owner who let that pool turn into a hazard bear any responsibility?
Or does the fact that the child was, technically trespassing, does that just absolve them of all liability?
Exactly.
That's the core conflict. And to understand how the court resolves this, we have to walk a really specific analytical path. We're going to start with the traditional common law view of trespassers, which is very harsh.
Okay.
Then we'll look at how Ohio moved to adopt what's called the attractive nuisance doctrine, specifically because of this case. We're going to dissect the restatement of torts, Section 339, and then finally we'll close the loop with the rescue doctrine and how it applied to the mother.
All right, let's get into the doctrinal analysis then. Before Bennett v. Stanley changed the game, what was the landscape like? If I own a house in Ohio, say back in the 1990s, and someone comes onto my land without permission, what's my duty to them?
Historically, and this is the black letter law that stood for a very long time, a landowner owes a trespasser virtually no duty at all.
No duty.
Almost none. If you come onto my land without an invitation, you take the premises as you find them. The only obligation I have is to refrain from willful, wanton, or reckless conduct.
Willful and wanton, that sounds like I have to be actively malicious. So basically, I can't set a bear trap for you, but I don't have to fix the broken steps on my porch.
That's precisely right. Negligence, just being careless, wasn't enough to create liability for a trespasser. The law really prioritized the sanctity of property ownership. The thinking was, you shouldn't be there, so I shouldn't have to spend my money making my land safe for you.
And this comes from an older time, right?
Yeah, an older, more agrarian society where your neighbor might be miles away. Your land was your kingdom.
But here's where it gets complicated. Does that rule change if the trespasser is a 5-year-old kid? Before Bennett, did Ohio law treat a toddler wandering into a yard the same as, an adult burglar?
And that is the conflict. Ohio had wrestled with this. They recognized that children are different. They don't have the judgment of adults. So before Bennett, there was a very narrow exception called the dangerous instrumentality doctrine.
Dangerous instrumentality?
Sounds intense. What does that cover?
It applied to the active operation of hazardous machinery. The classic example is from a case called Coy, where a 6-year-old touched a high-voltage transformer.
Oof.
Yeah. Because the company was actively operating this deadly piece of equipment, they were held liable. But the courts were very, very stubborn about distinguishing between active dangers, like running machinery, and passive dangers, like a broken staircase or just a static body of water.
So let me get this straight. If I'm running a buzzsaw in my yard, I'm liable. But if I just dig a giant pit and leave it there, that's passive, so I'm off the hook.
Under the old regime, yes. And that is exactly the distinction the Bennett court had to confront. The pool in this case wasn't operating. It was just sitting there.
So under that traditional rule, the Stanleys argued they owed no duty to the child because they weren't engaging in willful or wanton misconduct.
Which brings us to the case itself. We need to do a full diagnostic here on Bennett v. Stanley to see how the court just dismantled that old way of thinking. So let's analyze Bennett. First, what are the legally dispositive facts?
Okay, here's the situation. The Bennetts moved in right next door to the Stanleys. And we're talking close proximity. The houses were only about 100 feet apart.
Very close.
The Stanleys owned a swimming pool, but it had been abandoned for 3 years. The condition of the pool was, well, they had removed the tarp, they had removed the fencing on 2 sides. It had filled up with about 6 feet of rainwater.
6 feet?
It was slimy with algae. It had tadpoles, frogs, snakes. There were no ladders. The court actually described it as being pond-like.
And the crucial part.
Crucially, the Stanleys knew the Bennetts had young children. Chance was 5, Kylie was 3, and they had seen them playing outside unsupervised.
So they created a pond, stripped away the safety barriers, and knew little kids were 100 feet away. What happened next?
The Stanleys took no action. No warning to the neighbors, no attempt to secure the pool. On the day of the tragedy, Chance went over to the pool, likely to look at the frogs, and he fell in.
And couldn't get out.
Because of the algae and the lack of ladders, he couldn't get out. His mother, Cher, jumped in to rescue. Tragically, they both drowned.
It's just a gut-wrenching set of facts. So, legally speaking, what was the core issue before the court?
The issue was this. Will Ohio adopt the attractive nuisance doctrine, specifically Restatement Section 339, to impose a duty of ordinary care on landowners for child trespassers, and in doing so, overturn that old standard that only required refraining from willful or wanton misconduct?
So it's a huge pivot from don't hurt them on purpose to you actually have to be reasonable. So what rule of law did the court apply? Can you state the full black-letter rule and break it down into its elements for us?
Sure. The court officially adopted the restatement of the law, Torts, Section 339. This is the attractive nuisance doctrine, and it has 5 distinct elements that all have to be met for a landowner to be liable.
All 5. Okay.
First, the place. The possessor knows or has reason to know children are likely to trespass. Second, the condition. The possessor knows or has reason to know the condition involves an unreasonable risk of death or serious bodily harm.
Got it.
Third is the youth. The children, because of their youth, don't discover the condition or realize the risk involved.
Right, they're kids.
Fourth is a balancing act. Utility versus burden. The utility to the owner of maintaining the condition and the burden of eliminating the danger are slight compared to the risk. And finally, fifth, care. The possessor fails to exercise reasonable care to eliminate the danger.
Thank you. That is a really robust framework. Now, for the court's elemental analysis, let's walk through this step by step. How did the court apply that first element, the likelihood of trespass?
This is all about foreseeability. And the court found this element was absolutely met. The Stanleys knew the Bennetts lived right next door with young children. They'd seen them outside unsupervised. That proximity, just 100 feet, made trespass foreseeable.
So it's the fact that they were neighbors.
Yes. The court actually distinguished this from another case, Elliott v. Nagy. In Elliott, a visiting child drowned, but the court said that was unforeseeable because the owner didn't even know the child was there. In Bennett, that neighbor relationship is what creates the reason to know.
Understood. Okay, now, what about the second element, the unreasonable risk?
Here, the court looked at the specific state of the pool. It wasn't just a body of water. The court saw it as a trap. The slimy sides, the algae, the total lack of ladders, and the 6-foot depth meant that once a child fell in, escape was basically impossible.
It wasn't an obvious danger.
Exactly. It was a deceptive one. It posed a risk of death that the owner should have realized.
It lured them in with frogs, but prevented escape with the slum. A terrible combination. So what about the third element, the youth and the discovery of risk?
The analysis here focuses on the fact that Chance was only 5 years old. The pool looked like a pond full of frogs, which is attractive to a little kid. Because of his youth, he would not appreciate the danger of those algae-slicked sides or the depth. He just sees fun, not drowning hazard.
Right.
The whole point of the doctrine is to protect them because they lack that cognitive ability to properly assess risk.
That makes perfect sense. It's why it's called an attractive nuisance.
That's
Now, the fourth element is that balancing test. Utility versus burden. How did that weigh out here?
This was pretty clear-cut for the court. The pool was abandoned. It had been unused for 3 years, so it had zero utility. It wasn't being used for swimming or for aesthetics. The burden to simply drain it or fence it properly was slight.
And the risk?
The risk to the child was death. So the balance weighs heavily, heavily in favor of liability. You have very low cost to fix the problem and an incredibly high cost of failure.
Zero utility, high risk. That's a bad ratio for the defendant. Finally, the fifth element, reasonable care. Did the Stanleys exercise it?
They did not. In fact, they did the opposite.
Yeah.
They removed the fencing and the tarp, allowing this dangerous condition to develop without any warnings or safeguards.
Yeah.
They essentially dismantled the safety features that had been there before.
And after analyzing all 5 of those elements, what was the court's final conclusion?
The court reversed the lower court's summary judgment. Ohio officially adopts the attractive nuisance doctrine, And the case was remanded, sent back down, to determine if the specific facts satisfy the elements before a jury.
Okay, that covers the child chance, but we can't forget the mother, Cher. She was an adult. She jumped in to save him. Does this attractive nuisance doctrine, which is really designed for kids, apply to her at all?
No, and that's a great question. This is where we bring in the rescue doctrine.
Right.
Now, generally, an adult trespasser is owed no duty, just like we said at the beginning.
Right.
However, the rule here is, if a rescuer is injured while attempting to save someone who was exposed to danger by the defendant's negligence, that rescuer is then owed a duty of ordinary care.
So her legal status actually changes because of why she was there.
Exactly. If Chance was endangered by an attractive nuisance, which is a form of negligence, and Cher entered the property to save him, she assumes the legal status of the child she's trying to rescue.
So she's no longer a mere trespasser.
Correct. She is owed a duty of ordinary care. The law essentially says, you created the danger that forced her to act, so you are responsible for her safety too.
Is there any limit to that? I mean, can I just dive into any dangerous situation and then sue someone?
There is a caveat. The rescuer must not have acted rashly or unnecessarily exposed themselves to danger. But, diving in to save your drowning child is generally considered reasonable, even heroic. So the doctrine absolutely protects her.
It really connects the dots. If you're liable for setting the trap, you're liable for the person who gets hurt trying to spring it. I want to step back for a second. We've talked about pools, but the sources mention that this whole doctrine started with something completely different. Railroad turntables.
It did.
Let's do a hypothetical to see if this doctrine holds up in a different context. Imagine a railroad turntable, a massive rotating platform. It's unfenced, it's near a town, and kids are known to play on it. It crushes a child's leg.
This is the classic attractive nuisance origin story from a case called Sioux City and Pacific Railroad Company v. Stout. We can just run it right through the Bennett framework.
Let's do it.
Okay, element 1, place. Known trespassers near a town, yes. 2, condition. An unreasonable risk of being crushed, absolutely, yes. 3, youth. Do children realize the immense mechanical force? No.
And the balancing test.
4, utility versus burden.
Yeah.
The turntable has a high utility for the railroad for sure, but the burden to just lock it is incredibly low.
So the balance still tips.
It does. And then 5, care. They failed to lock it. It fits perfectly. This is why the doctrine evolved from being just about turntables to covering general artificial conditions like the pool in Bennett. The logic is identical.
It's amazing how a rule designed for steam engines applies to a swimming pool a century later.
Yeah.
It just shows the law adapting to reality.
It does. And it signifies a really important shift in values. The court in Bennett explicitly noted that society has shifted from rural to suburban living. In a more crowded society, neighborliness actually becomes a legal duty.
So for the law students listening or just the legally curious, we have covered a lot of ground. I want to synthesize all this. If I'm looking at a fact pattern on an exam, or heck, just looking at my neighbor's yard, what is the checklist I should run through?
Right. Okay, here is your child trespasser and rescue checklist.
Identify the plaintiff. Is it a child trespasser? If so, you proceed.
Step 1.
Step 2. Check for active negligence. That's the old COI rule. Is the owner actively operating dangerous machinery? If yes, a higher duty applies immediately. If not, go to step 3.
Yeah.
3. Apply attractive nuisance. Section 339. And here you have your mini checklist. A. Foreseeability. Did the owner know kids were likely to be there? Remember the Elliott case, it has to be foreseeable. B. The condition. Is it an artificial condition? A pool, equipment, something man-made?
Right.
C. The risk. Is it an unreasonable risk of death or serious harm? D. The mind of the child. Did their youth prevent them from realizing that risk? And E. The balancing test. Is the burden of fixing it slight compared to the risk to the child?
What's the last step?
Step 4. Identify the rescuer. Is there an adult who intervened? If so, you check for derivative status. If the child was owed a duty, the rescuer is also owed a duty. And the standard for them is ordinary care unless their rescue attempt was, rash or reckless.
That is an incredibly powerful tool. It takes this complex emotional situation and just gives it a clear structure. We've moved from protecting property rights above all else to recognizing that a changing, more crowded society requires protecting children from these hidden traps next door.
It really does. And if I can leave you with one final thought, it's about that foreseeability element. The court essentially codified a form of neighborliness, It's no longer enough to just stay on your side of the fence. You have to anticipate. You have to look at your own property, not through your eyes, but through the eyes of a curious, fearless 5-year-old.
And that is now your legal burden.
That's your legal burden.
A sobering but really important takeaway. Look at your world through the eyes of a child, because the law certainly will. Thanks for joining us on The Deep Dive. We'll see you next time.